whether it's joint venture dispute, production sharing disputes, EPC arrangement, contracting, regulatory, environmental obligations, and of course, the growing impact of energy transition. All of these disputes present both challenges and opportunities for practitioners. Today's webinar seeks to demystify the landscape. We hope that at the end of it, we would have explored the nature of disputes that typically arise in the sector and examine how they are resolved in practice. We are hoping that at the end of today's session, whether you're a lawyer, you're an arbitrator, an expert, or in-house counsel, you will have enough that will enable you position yourself to build a meaningful career in the specialized industry. Our objective is to have a practical conversation, and we are hoping that you will also contribute by engaging with us with your comments, with your questions in the chat box. So you are encouraged to make it as interactive as possible. Feel free to submit your questions and to also your input or your comments at any time. We'll pick it up from there, and we'll try as much as possible to address them as many as possible as the time permits. Joining us today, for this important conversation are, a panel of, I'm particularly privileged to have with us today distinguished panel members comprising of experts, leading practitioners from London, from Dubai, from Nigeria, bringing perspectives from private practice, industry, regulation, in-house, the private, the first user of arbitration and arbitral decision-making experts. And I will start by introducing my first speaker, Mr. Matthew Weniger, the King's Counsel, is joining us from Linklaters. He's a partner in the international arbitration practice at Linklaters LLP London. Matthew is a leading international arbitration practitioner with extensive experience in commercial and investment treaty disputes across arbitral institutions, including ICSID, ICC, LCIA, and many more. He has acted in numerous high-value energy arbitration, particularly in emerging markets. Please join me to warmly welcome Matthew. Matthew, a word or two.
Thank you, and it's an absolute pleasure to be here, and many thanks, Nike, for this invitation. I'm very much looking forward to this.
All right, then. Our next panelist is Ikechukwu Ekweme, is a Vice President, Legal and Company Secretary at Renaissance Africa Energy Company. Ike is a distinguished legal and governance leader with over 27 years of experience spanning private practice and global energy operations. He has spent more than 2 decades with Shell in senior international legal roles, including as General Counsel, advising on energy projects and joint ventures, M&A transactions, and complex disputes across multiple jurisdictions. It comes with in-house perspective. You're welcome, Ikechukwu, to this discourse.
Thank you. It's my pleasure to be here. I'm looking forward to an engaging session. Thank you.
Okay, thank you very much. Joining us from the regulatory side is Augustine Okwa. He's a coordinator of the Upstream Petroleum Alternative Dispute Resolution Center at the Nigerian Upstream Petroleum Regulatory Commission. With over 2 decades of experience in petroleum regulations, policy implementation, dispute resolution, and environmental law, Augustine has played key roles in several landmark industry initiatives, including the Petroleum Industry Act implementation process and the Nigerian Gas Flare Commercialization Program. Join me to welcome Augustine to this webinar.
Good morning, everyone. It is my pleasure to be here this morning, and I look forward to a very interactive engagement today.
Okay, so while Augustine is here with us, he's somewhere else right now where it is evening. So thank you for taking out time of your to join us today. And of course, the last but certainly not the least is Nesrine Usman, our final panelist for this morning. She's a partner at St. Masons based in Dubai. Nesrine has nearly 20 years of dispute experience, including over a decade advising on complex high-value arbitrations across Middle East, energy, and infrastructure sectors. She regularly acts as counsel and arbitrator under major arbitral rules and is consistently recognized as leading international arbitrator for her expertise in construction, engineering, and energy disputes. You're welcome, Nesrin.
Thank you very much, Adenike. It's a pleasure to be here and join this distinguished panel. Looking forward to the session.
So thank you very much. And just before we continue, a few housekeeping rules. If you are joining us and you are trying to book CPD points, please, you do not need to, impute your details, your call number, your Supreme Court number, all of those details. We don't need them in the chat box. Just to the extent that you have registered and you've provided accurate details, you will get your CPD point issued by MBA ICLE. Then also, please feel free to, like I said earlier on, put your comments and your questions in the chat box, and we'll take it from there. So without much ado, again, you are welcome. This webinar is hosted by the Chartered Institute of Arbitrators Nigerian branch. We'll talk more about the Chartered Institute in the towards the end of the webinar. So by way of, setting the scene, we are, again, the topic is oil and gas arbitration, unlocking value. I'll start with you, Matthew. Matthew, you have handled major international arbitration across a wide range of sectors. What is so special about oil and gas arbitration? What makes oil and gas disputes different from disputes in other industries?
Yeah, that's a really good question. I think there's three things that stand out in particular. The first is that the scale of these arbitrations and the matters at stake are so large. I mean, I was involved last year in an arbitration related to preemption rights over an oil field in Guyana. The oil field was worth $66 billion. And there are not many cases where you've got so many billions of dollars at stake. And this is because obviously a functioning oil field will have an incredibly high value. These are capital intensive deals. There are prominent corporations, some of the world's biggest corporations are involved, and also many state interests. And all of this reflect in the scale and importance of the case. So that's the first thing. The second thing is that the contracts underpinning the arbitration are often distinct. The applicable instruments require an understanding of industry-specific practice. And there's particularly when we're talking about upstream oil and gas, many of the contracts are based on model forms and developed by the Association of International Energy Negotiators, the AIEN. And there's a distinct advantage to have done a number of cases involving these model forms, because you then understand where the weaknesses, where the sometimes the uncertainties in these model forms exist. And the final point is that they are often extremely technically complex, which means you need specialist arbitrators who can deal with engineering problems and the ability to work with experts who will provide engineering and other input. The sort of technical disputes you'll have: reservoir engineering, drilling operations, production, sharing, mechanics. And so taken together, these three things really make oil and gas arbitration different from other arbitrations.
Okay, thank you so much. And we've heard about the capital-intensive nature of oil and gas projects, and that is why you find such disputes. Now, that is from you, the counsel, and the arbitrator. Now, let's go to the in-house. They are the ones that manage the disputes. They are the business advisors. So I'm going to go to you, Ike. You have spent over 2 decades at the heart of global energy operations. Tell us, from your own point of view, tell us what's so special about your industry. What is it about the scale, the risk, the structure of oil and gas business that makes it so unique, that makes it deserve a dedicated discussion such as this, like the one we are having?
Thank you, Nike, and thank you, everyone. And very good question from a context-setting point of view. I think the best place to start is the basics, which is to try to highlight the importance of the industry itself and dimension what it means for each and every one of us and for the nations across the world. You would clearly note by this time that oil industry remains one of the influential drivers of global commerce, industrialization, and the economics of many countries. And therefore, it is of significant economic significance to people, to nations, and to companies. And let me speak to scale a bit in terms of how it impacts us as individuals. You will see that almost every household you would use petroleum products every day, be it as transportation, for cooking, plastics, lubricants. We come in contact with oil and gas products, byproducts, and also likewise for countries where the resources coming out of oil and gas extractions are required for national budget, but most importantly to power development, power industries, and it is the energy for the future and energy for today. And of course, the recent event that we've all been watching in the Strait of Hormuz, we've actually seen the impact of that incident on global energy market and how interconnected the world remains with respect to oil and gas. So what is happening far away Middle East, touching everybody around the globe, and that is the dimension, the scale, and the power of the industry. And in terms of speaking to risk, you would kind of also clearly recognize that the industry is significantly capital intensive, as Matthew already highlighted, specialized technology, long-term commitment, and of course, high barrier to entry. Commercial operations are quite substantial, highly regulated in most places, and this is an industry that is keen and that is very close to the heart of most governments and nations. And you will see that, you can't actually successfully operate in this country without, working with government, investors, technical partners, and different types of stakeholders, financiers. And in terms of structure, there's also that importance around looking at what is the optimal structure from an investor company point of view that delivers value to company, to shareholder, to state, and to the nation. So let me leave it here, but just to make sure that we clearly understand that this is an industry that requires special focus. And clearly, because of the complexity, disputes is an integral part of the operation. How we manage it is a conversation we're going to have today. Thank you, Nike.
Thank you very much. Yes, indeed. Disputes is an integral part of the operations, and it is a highly regulated industry, I must say. And that is why I'm going to be asking the regulator, who has an overview of the whole spectrum of disputes, because at one point or the other, they get to know. And that's why I'm going to be having this conversation, asking Austin, from a regulatory perspective, what are the most common disputes currently arising in the Nigerian upstream petroleum sector, at least those that come to you?
Thank you, Dr. Nike. So basically, the most commonest dispute from a regulatory perspective has to do with regulatory compliance issues. And then because of the multidimensional stakeholders nature of the industry, you then have a lot of disputes emanating between license holders and co-license like the contractors. And interestingly, after the 2020 licensing round that was done by the Nigeria Upstream Petroleum Regulatory Commission, you then have more than 2 or 3 companies being awarded an asset. And then these entities are required to form a special purpose vehicle to operate the assets. I can tell you, Dr. Nike, we have had plethora of cases from these parties among not being able to reach amicable JOA that will lead to the successful formation of the SPV for the operation of the assets. And then you have issues about having third-party financiers who had funded the payment of signature bonus for some of these awardees, then having to say that they had some sort of agreement outside the award process that was not known to us as at that time, and now they want to enforce agreement they've had with the awardees. So we've had to deal with a couple of these matters. And again, now with the PIA that gave a framework for the host community trust development fund, it has now introduced another layer of disputes between the settlers and the host communities as a determination of who qualifies to be a host community. Now, clearly, the PI defines who is a host community. And then, but you see communities who do not fall under the purview of this definition going to court to say, oh, we ought to be in that host community trust fund. And then you have issues on selection of the trustees. The PIA spelled out that the settlers in conjunction with the community will select the trustees. And there are a lot of cases dealing with that. And the PIA spelled out the fund administration mechanism. So there have been plethora of matters and cases around this. Beyond that, you then have disputes arising between license holders, the operator of the assets, and third parties like contractors. You see contractors writing to us to say, we have performed some duties for the operators for the development of the assets. There are payment obligations that they are yet to fulfill. And so we, as a regulator, and you know, the essence of our regulation is to ensure that we create an enabling business for operations of various operators in the country so that we can increase production as well as increase the revenue to the federal government. And any dispute that is not properly managed early enough impacts on this global goal of the country. So we sit on all of this and we strive as much as possible to ensure that these disputes, in as much as some of them are contractor, some of them are not contractor, do not impact on the development of the assets. Thank you.
Thank you. From your response, I can see that what I can take away is that there's the multidimensional nature of the disputes. You've talked about disputes bordering on regulatory compliance, disputes between joint venture partners, dispute involving host community, indigens, involving the settlers, and who qualifies as host community, which community qualifies as host community under the PIA. Quite a wide range of disputes. And at the end of the day, then you also talked about contractual disputes. So on that basis, I'm going to be asking Nesrin the next question. And this is with respect to the engineering, procurement, and construction disputes contracts. What are those disputes why are these projects so prone to high value disputes? That is the EPC contract. Austin has informed us that you have contractual disputes between the operator and contractors, and EPC is one of those contracts. Why are these projects so prone to high value disputes? And in other words, why do EPC contracts in the energy sector often lead to high value dispute? And this is on the basis that I'm asking this question because I know that you do a lot of EPC contract disputes resolution.
Thank you, Adenike. I mean, I think a couple of factors have already been covered. Matthew mentioned earlier the sheer scale and the technical complexity. These are multi-billion-dollar projects, life cycles measured in decades. So they're huge scale. They're very technically complex. The engineering alone is really specialized. You've got Matthew mentioned earlier, reservoir engineering, drilling, subsea systems. Then you've got the downstream processing facilities. So all of these disciplines have their own sort of specialists, their own standards, their own language. Quite often you'll find there's multi-party project structures as well. So we mentioned some of this. You've got the national oil companies, IOC's joint venturing, you've got the production sharing contracts, and the host governments are involved. And then you've got my little bit, the EPC contractors, subcontractors, the equipment vendors. All of these interfaces are potential areas of dispute. And then when something goes wrong, everyone sort of looks to the side or up and down, but nobody really looks in the mirror to see if it was themselves. So the disputes become entrenched. There's obviously also the geopolitical dimension. These projects, oil and gas projects, often straddle borders, physical borders, legal borders, political. They're operating in jurisdictions where the regulatory environment can shift. With a change in government, you can have sanctions regimes applying, sometimes impacted by conflicts. That's very close to home for me at the moment. So all of that adds enormous complexity. And then I guess in terms of sort of the disputes that come out of it that I see, are obviously the classic sort of construction disputes. Delay and disruption claims, scope disputes, variation disagreements, non-certification, non-payment, cost overruns. All of these things collide in one dispute, often an EPC contractor dispute. It's a unique sector, so obviously there's other disputes that happen in other areas, like take-or-pay disputes and production sharing disputes, etc. But I think for EPC, for my world, if you like, it's a combination of the technical complexity, the fact that it's often multi-party structures. You've got these really long project durations with really high stakes. So I think that's really what makes oil and gas arbitrations and disputes genuinely their own sort of unique discipline with their own unique challenges.
Okay, thank you. Unique challenges. And these disputes present unique challenges and opportunities. Ikechukwu, please, can you tell us what, from the perspective of an energy company, what types of disputes keep management and legal teams most concerned today, given the fact that there is a multidimensional nature of the dispute emanating from the oil and gas industry and the high value, the capital intensive investment already, put in place by the investors and the owners of the business. So what kind of disputes can you tell us keep management and legal teams most concerned today?
Thank you, Nike, once more. And I will start by saying that naturally, this will vary from one company to another, depending on their nature of operations, their risk profile, and the jurisdiction. But most importantly, we need to recognize that you have the producing company and the service companies. And I will speak more from the producing company perspective. I would largely, in terms of first three, to look at investor-state dispute. It's number one, and I will come to that. The second being a dispute with regulators and environmental dispute generally. And of course, there's a whole line of other types of disputes that keep general counsels and legal advisors in-house busy. But let me go back to the investor-state dispute and try to unpack why I think it's the most important dispute that you worry about and is, really think through if and how you want to manage such disputes. And it's at the level of challenging the host country in adversarial proceedings. It's very serious and existential. And if you have to make that decision, it's a decision that you don't make lightly. And most of the time, the issue then, speaks to maybe expropriation or, unfair treatment. And to the point that companies decide to take a state to arbitration. And at the end of the day, you recognize that you have to work in this country and you have to work with the government. You have to enforce this arbitration, the outcome of the arbitration, but you would have to take that decision if you get to the point. And I think for the BITs that have participated, the time that it took to talk through senior management to accept to sanction that arbitration and the recycling of that process speaks to the seriousness. And you get to the point where have you engaged, had the opportunity to still further engage the state. So investor-state dispute is, if you get to that point, it is one of the major decisions that you would have to take as a general counsel leading a company, making that decision to take a host government to arbitration or to courts. But another most important is the regulator, where my friend Austin sits, for example, NUPRC. And you don't want to find yourself in an adversarial proceedings with your regulator, because they're two important relationship. Basically, you will need the regulator, whether you succeed or not. You will have to still come back to Mr. Austin and then UPRC for permits, for all sorts of, different things. So it's another important type of dispute, and the long-term partnership and working together with the regulator is important. And such dispute or disagreement, there's always a major effort to find a resolution before you take it to arbitration or any form of adversarial proceedings. And we continue to see more professionalism and the collaboration with the regulators trying to work things out as against finding ourselves in court or in arbitration, which it's very good because it creates that room for greater constructive conversation and engagement. But to answer your question, Nike, it is a decision to take NUPRC or NOSDRA or the Ministry of Environment to arbitration. It's actually a big deal. And the other one also, the third one, and I've said a couple of other disputes, but environmental dispute, beyond the reputational dimensions, the claims are largely overstated, but there are also clearly deserving environmental disputes that we encounter, and as a company policy, we try to resolve and settle those disputes. It could be that the litigation, the arbitration or the dispute is speaking to the quantum. Okay, I agree it happened. Assessment is X, your view is Y, we are disputing quantum. But also there are cases where it's sabotage, it is third-party interference, and people are looking for windfall payments. It's also even very, very difficult for you to manage such disputes within an ADR or platform. Most of the time, it's so contentious that you end up in court. So again, no company wants to be perceived as being litigious or disputing things, but clearly, as I said, given the complexity and the nature of the operations, dispute will arise, be it with the state, be it with the regulator, be it with the host community. And we have seen increasingly, as Nazrim said, with the service contractors, because of the nature of that operations, there's always dispute within that space. So in rounding up, the investor-state dispute remains number one, followed by dispute with regulator Mr. Austin, which so far so good. We've not had one, and the ones that we've had, we are managing it more collaboratively, recognizing the long-term relationship. I think we've had a couple, Mr. Austin. I now recall we've had a couple, but I think we are still managing those. So I'll leave it here.
And I hope you continue to manage those like you rightly recognized, you can't do without them. While you may be trying to resolve an issue, you are also trying to get different permits, different approvers. You don't want to be on the wrong side of the operator, whether it's NUPRC, whether it's NIMS, or whether it's NMPC. And I hear you very clearly, making a decision to take out the whole state where you have captive investment, to international arbitration. And obviously, by the time you're going by way of investor-state arbitration, it's got to be something consequential, something significant. I can imagine the number of memos, justification, presentations that one would need to make before it's approved all the way. And thank you for sharing that. And I'm going to just go straight to Matthew, who we are privileged to have on this webinar. He has acted acted as counsel in investor-state arbitration. So he understands totally what this means and the impact and the implication. And on this, I'm going to be asking, given the fact that oil and gas law sits at the heart of national sovereignty, while energy company projects are often substantial, and they also have rights of stability, contractual stability, legal certainty. They want it to be treated fairly and equitably. They want their assets and their investment given full protection and security. They want all of the commitments made to them to be kept. On the other hand, the sovereign states, the host states, they also have rights. Rights to enact new laws, pursue public policy objectives, particularly in the context of global energy transition and physical reforms aimed at increasing government take. So how do you think tribunals balance this, conflicting, expectations and rights and obligations of both the host state and the investor, the oil and gas company investor?
So that is actually key. That is the key, because many cases, if you look at the underlying fact patterns, you can't work out really who is right and who is wrong and who deserves to win. Many cases are somewhere in the middle, because the state has the right to regulate, but at the same time, the investor has received commitments. And tribunals do look for balance, and certainly if I can use the phrase again, well-balanced tribunal will look for balance. But this creates its own difficulties in the system of investor-state arbitration, because it means that the decisions are very unpredictable, because you just don't know where the tribunal in advance is going to come down when it comes to looking at the balance. I always like to use a description of fair and equitable treatment. If you think about it, fair and equitable is 3 words. One of them is and 2 of the words mean the same thing. So what guidance are you giving to arbitral tribunals by telling them to look for fair and equitable? Because there's no guidance. It doesn't mean anything, really. So as a result, the balance that the tribunal is looking for, it's very hard to predict in advance. So if you take, for example, expropriation, you have the treaty text is not going to help you very much, because most treaties allow expropriation for a public purpose, if it's non-discriminatory, in accordance with due process, accompanied by the payment of full compensation. But there are other criteria going the other way. Sometimes tribunals look outside these principles, and for example, the idea of police powers, where states don't have to pay compensation if measures are aimed at general welfare, public health and safety. And all of these are just principles that are thrown into the mixed together with the factual underpinnings, and that makes the balance very hard to find. Another place where the balance is difficult is in looking at prior commitments, in particular legitimate expectations when it comes to the world of fair and equitable treatment. And there's a hierarchy of expectations. If that expectation has been given in legislation and that's been relied upon, that may well be respected. At the other end, If it's just in offhand comments made by politicians at meetings, that's less likely to be respected because, unfortunately, speaking as somebody English, I won't say what happens in Nigeria, but in England, politicians lie, and not everything they say can be relied upon. So a tribunal will expect an investor to be very cautious about relying upon statements made by politicians. And then what is difficult is where you're in the middle, where you have a very formal statement made by the highest level of government. It's not legislation, but it was clearly made, for example, in an investor briefing pack in a meeting when the investor said, if you need to give me this before I invest. But they don't get a stabilization clause. So where are you going to balance this out? That makes things very difficult. And I'll just say that another area where the balance is very difficult is taxation. Taxation often arises in oil and gas disputes because obviously hydrocarbon taxes are a source of government revenue, and the state will always change its tax rates. But if the tax rates are fixed to some extent in the PSC or in the concession agreement, then you're going to have a clash between the government's right to change its tax rates and commitments given to investors. So there's no clear answer here. Finding this balance is extremely difficult. That's what makes these cases so interesting as a lawyer, but it's very hard as a client, because when a client comes with a problem and says, are we going to win? Which is obviously their first question. The answer as a lawyer is often, well, I don't know. And that creates this enormous level of uncertainty, making things very difficult. Anyway, I'll stop there. It's an absolutely fascinating question.
Yes, the uncertainty about whether you're going to win or not is one of the reasons why it's very difficult. It makes it very challenging for the legal team, such as Ike's team, to justify it to his management. You never know how it's going to swing, even with all of your facts and all the things that you want, should I say, the merit of your case. Thank you so much for sharing. And I'm going to be asking Desiree the next question. From your experience as both counsel and arbitrator, what distinguishes a well-managed energy arbitration, whether it's commercial arbitration or investment arbitration? What distinguishes it from one that becomes unnecessarily lengthy and expensive? We just want to know what is a well-managed arbitration, energy arbitration is.
So I like the way you think I can speak about well-managed arbitrations. I think that's a good thing.
I'm hoping you can.
I can tell you the difference is usually visible within the first few weeks of a case, to be honest, and it comes down to a few things. First, to ensure that your arbitration is well managed, I would say that you have to have a really early and honest case assessment. A well-managed case starts with the legal team genuinely stress testing the client's position. In oil and gas disputes, there's often enormous pressure from the client's commercial team to pursue every claim and resist every defense. And that could lead to really bloated pleadings that cover everything and sometimes focus on nothing. And in my experience, the cases that run really well are the ones where we've been able to sit with the client early and say, look, here's your good points, there's really strong points, here's your weak points, here's what we actually need the tribunal to decide. And these really focused cases tend to move faster, they tend to be cheaper, less stressful. The second is, I think, procedural efficiency. A good PO1, procedural order number 1, sets the architecture for the whole case. And so the arbitrators that do well, I think, are the ones that push hard for realistic timetables, very realistic timetables, no asking the parties in an oil and gas dispute to have their memorial style statement of claim ready in 6 weeks, because it's just not going to happen. Control over document production. It needs to be genuinely targeted, not a fishing expedition, and then sort of clear rules around expert evidence. So procedural efficiency helps. Third, I think, is expert management. So in oil and gas cases, you'll almost always have multiple experts, delay, quantum, and at least one technical expert. as a minimum. And so an arbitration can quite easily sort of spiral into the situation where you've got 6 or 7 expert reports sort of flying around in every direction. And I think cases that work well are those where the experts are sort of focused on key issues in the dispute. They use the joint expert meetings properly, they agree joint statements, they try to narrow down the dispute. I'm a fan of hot tubbing. I don't know if all lawyers would say that, but I like hot tubbing. I think it's really helpful for the tribunal, particularly in these really complicated oil and gas disputes. It does 2 things. It allows the tribunal to ask questions just from a technical perspective that they haven't managed to work out from the expert reports, but also allows them to test the 2 experts live, which I think is helpful from the tribunal's perspective. I think the final point that's really important and often gets forgotten is proportionality. Not every point deserves to go to a hearing. And I think the best advocates are those who can identify the 2, 3, maybe 4, 5 key issues that will actually determine the dispute and the outcome, and sort of frame the case around those, rather than giving the tribunal, 50 issues and, go through 45 of them in real detail and sort of ignore the other 5. In my experience with the cases that sort of go wrong have a very similar sort of pathology. The parties dig in their positions really early on and they refuse to budge on anything, including procedural issues. Document production is just outrageous and the battles take months and millions in fees. And the expert teams just sort of talk past each other because the questions haven't been framed properly. And so I think the short version of all of that is I think you need discipline, control, you need focus, and you need early sort of case management to make sure that the cases focus on what's really important, what's actually got to be decided by the tribunal.
Okay, thank you. Early case management. Now, from the perspective of in-house counsel, where I sit, sometimes we want to just put everything out there. And, sometimes we just want to because we want to win. That's the prerogative. So hear from us. So yeah, we listen to our counsel, we listen to you ultimately, but when you say that, we like to win. And when you talked about experts, technical experts, I've actually been involved in an arbitration where we had about 4 experts, and in one of the reports was as voluminous as 300 pages. That is the nature of oil and gas disputes. Sometimes you just need those experts. And I'm going to come back to Matthew or you later on to explain to our participants here. Most of them are not they are laymen in this field. What is hot tubbing? And when we are talking about experts, I'll come back to that. But let me go back to Austin for a while. And let's look at NUPRC, the regulator that we must not cross. That we have a long-standing relationship, like Ike said. So it's something that, and it's in anybody's interest to have any dispute resolved. Talk to us about the ADR Center. This is your 3-minute pitch. When was it established, and what was it established to provide? What gap was the center designed to fill?
Thank you very much,
ADR Center. How does it differ from traditional arbitration and litigation? Tell us.
So I want to start by first reassuring my friend, my brother, Dr. Ikechukwu, that NUPRC as a business enabler will try as much as possible to make the environment suitable for you to carry out your business. And we'll continue to partner with you because you're our partner in progress. We'll continue to partner with you to ensure that we increase production and then we increase revenue to the federal government. Now, the ADRC was set up to address disputes in the upstream oil and gas sector. So it is sector specific. And this is one of its kind. We know that oftentimes when dispute arises, when this multifaceted dispute arises, people want to either go to the conventional courts or you want to go to arbitration. And like Dr. Nike said, when you go to arbitration, what do you want to do? You want to win. And so it means that if you do not win, you have not achieved what you want to achieve by going to the arbitration. But the ADRC Center is then set up to give you a level playing ground whereby there is no winner, there is no loser. It enables the parties to reach an amicable resolution that will be facilitated by mediator, who will then allow the parties to reach an amicable settlement. The ADRC was established in 2021, and then we then had to bring in body of neutrals. This body of neutrals include experts in the oil and gas industry, retired judges, lawyers, and ADR practitioners, who would then sit as mediators over disputes that are being referred to the center. By the way, the ADRC Center is not an extension of NUPRC. So when disputes, because we've had that misconception that, oh, why should I take my matter to the regulator? No. When a dispute is referred to the ADRC, from the list of the body of neutrals we have, which I've enumerated to you the composition of the body of neutrals, from the list of the body of neutrals we have, the parties are then at liberty to then choose either a single mediator or a mediator or three mediators who would then sit as mediators over the dispute. And what then happens is that once the matter is referred to us, we facilitate the choosing of the mediators. And then once mediators are appointed, we sit back. The mediators will then mediate on the disputes. And what the mediators essentially do, unlike in arbitration or normal courts of law, they facilitate the resolution between the parties. So that by the time you finish, if you then reach an amicable resolution, it is reduced into a settlement agreement. And the Arbitration and Mediation Act of 2023 now makes the settlement agreement you reach at enforceable, and you can enforce it as a consent judgment in court. When you are leaving the mediation center, you'll be shaking your hands. What does that do? That continue to ensure that business relationships are still maintained. You will agree with me that we have emphasized that the oil and gas business is a highly intensive business venture. So take, for instance, when you are given a license, an oil prospecting license or petrol prospecting license, to drill a single well, it costs you huge amount of money. So you don't want anything that will store that. Specifically, we encourage you to exploit the ADRC Center for time quickly resolution of your disputes. It is cost efficient. It's not as costly as normal court nor arbitration, okay, and it strengthens relationship. Thank you so much.
Thank you. Thank you. Your 3 minutes is up. And I'm sure you have sold the NUPRC ADR Center so well, such that those that have disputes in the sector can always refer their disputes for mediation instead of arbitration or litigation. And our time is almost over for this panel session, but let me quickly ask Matthew. Experts, technical experts, how very important are they in resolving disputes? Can we do without them? Do we need as many as 7? Nesrin does not agree. Then in simple terms, explain to our participants what is hot tubbing? How does it occur? Thank you.
Okay, so hot tubbing, which I'm a big fan of, is in a really, as I said, the scale of these arbitrations is immense. And so sometimes you can have hearings that go on for quite a few days, a couple of weeks maybe, sometimes longer in construction disputes. And if the claimant's experts go first, then it could be a few days before the respondent's experts speak. And there's been many things that have been happening in the arbitration between that, and everyone's forgotten. So it's hard for everybody to really focus on what the experts are agreeing on and what they're disagreeing on. Hot tubbing, maybe because Nigeria is a hot country, you don't have hot tubs. But in a place like England, where it's usually freezing outside, a hot tub is like a large outdoor bath which is heated, and you sit in there and you chat to your friends. So that's where the idea comes from. That's a hot tub. You sit and you talk. So the experts sit side by side. So instead of having one person, one man or woman in the witness box, you have two, one from each side. And it works best when the tribunal is very informed and takes a lead and asks the important questions. And then you say, expert one, the pipe, there were bubbles at the top of the sea because the pipe was leaking. Why was the pipe leaking? And expert one says, well, it was leaking because the chemical composition of this was this and that, and these other chemicals weren't working here. And over time, the gas was of a certain chemical composition, and then you got a hole and you had bubbles on the sea surface. And then after hearing that, the tribunal will say, okay, expert two, what do you think of that? And expert two will say, well, no, it's not to do with that because this gas has this chemical composition. And actually, it's the welding, and this is what went wrong with the welding. And then the tribunal will hear this difference, and then they can say, okay, well, what do you have to say about his point? And what do you have to say about her point? And you very quickly get to the nub of the issues between the experts, rather than one expert going on at length with their answers and being challenged by counsel at length with their answers. There's nowhere for them to hide because they are being directly challenged in the hot tub. So that's what happens. It's a completely different dynamic. It really helps in bringing the proper issues in dispute to the fore.
Okay, thank you. Okay, we promised and we must deliver. We promised the participants that we would tell them of the opportunities and how to take advantage of the opportunities for their career in the course of this webinar. So I'm going to be asking you, who am I going to be asking first? Let me start with Nesri. For lawyers and arbitrators seeking to build a practice in the energy sector, what skills, sector knowledge, or experience should they prioritize developing?
The first thing I'd probably say is, it might be slightly counterintuitive, but you don't need to be an engineer. But what you do need is to be sort of functionally literate in the technical context. So there's a real difference between lawyers who can read from an EPC contract perspective, a project program, understand what critical path means. They can look at a P&ID, piping and instrumentation diagram and understand broadly what they're looking at. There's that sort of lawyer. And on the other hand, there's the lawyer who is completely dependent on the expert to explain every element of the dispute. So I think if you're technically literate, you engage much more effectively with the evidence, and you can sort of spot holes in the other side's case, and present arguments in a way that sort of actually resonates with everyone in the room. So and I would say invest time trying to understand the projects and how they work, read industry publications, but if you get the opportunity to visit sites, that sort of thing. Second, very, very important is obviously know your contract. So the energy sector has its own contractual ecosystem. You need to know FIDIC, Silver Book for EPC, Red Book for traditional contracts. These contracts have very specific risk allocation logics, and you need to appreciate that. It's not the same as coming from a sort of generic commercial background. I would say you need to sort of become very aware and build your procedural toolkit in terms of arbitration procedure. Energy arbitrations tend to be international commercial arbitrations. So the ICC, LCIA, SEAC, the regional ones here, DIAC, ADGM, the Arbitrate AD, which is the Abu Dhabi Arbitration Center. So know the rules, know the institutions, and the more that the more arbitrations you're involved in, the better. So this sort of in building your career, sort of look for opportunities to participate in that process, maybe as a tribunal secretary. So just get like a behind the scenes view, I guess, of how cases are managed. And then I think importantly, you need to sort of understand the domestic landscape as well as the international one. So there's often a lot of interaction between the domestic arbitration laws and the relevant sort of petroleum laws in a jurisdiction, and then obviously the international arbitration framework. And all of that mixing together is really, really genuinely complex. So sort of understanding the domestic and the international is really, really valuable. And then I think finally get involved in the community. So obviously the CRB is a fantastic place to do that. Get to know the people in the community, get involved, start speaking at things, publish articles on industry specific issues. I think the people that sort of thrive in this are those who are a combination of, genuine technical curiosity. You have to enjoy that side of it, or else this will not be a very fun job at all. But also the sort of the legal excellence, I guess, and then very strong interpersonal skills to get to know as many people as possible so that you can further your career.
Thank you very much. Genuine technical curiosity plus legal excellence. Understand the domestic and international landscape. And of course, get involved in the community. And CHAB is that community. So get involved, be part of what we do. Thank you very much, Nesrine. I'll ask Ikechukwu. When a multi-million-dollar dispute arises, what does an oil and gas company such as yours value most from an external arbitration counsel? And this is basically telling practitioners what you're looking for when you want to engage a law firm to handle some of these, your high-profile disputes, arbitrations.
Unique, and I think we also have a lot of those disputes. But in one sentence, it is the ability to align legal strategy with business objectives. I repeat it again, ability to align legal strategy with business objectives. And let me try and unpack it a bit. For the purpose of this discussion, I would assume that external counsel being considered for major energy dispute is technically competent. So I'm really not so much worried about that. That is basic. The difference usually lies elsewhere. A good dispute lawyer will look at dispute and immediately start thinking how to secure the best legal outcome, how to secure the win, which is important. The exceptional lawyer goes one step further and seeks to understand what success actually looks like from the client perspective. In other words, they seek to understand what will constitute a business win, not just a legal win. Key, because the company we are doing in business, really. I mean, we would want to get a win that delivers a business solution, not just, I've gotten this precedent and no, it doesn't cut it. So sometimes those two things are exactly the same. Sometimes they are not. But the latter, with respect to, the business win, is most important. And for example, it could be that what is most important for me in this situation is preserving the commercial relationship or just the relationship, with Mr. Austin in NUPRC, irrespective of the dispute or how we want to win. The relationship is important. So in going into engaging that lawyer, a lawyer that ensures that that outcome fits into the overall win is critical. And it could be that the most important thing is, business continuity. The lawyer must understand what priority, what outcome delivers greater value. You must put on the value lens from the business, the business views. What does the business want, and what creates value? Not so. again, the lawyer I'm looking at for, is a lawyer that takes time to understand the industry. Nesrin, you said that a bit. It does, the lawyer understand how dispute affect different operations. You will kind of need to really know what is important, how are the operations interconnected. You understand the risk and managing. What are the broader business implications of the outcome and the decisions that I need to make? How this lawyer also works collaboratively with the client, with me. We must stay engaged at every step, working together, going through the process. Because I understand the business, I understand my operational realities. I ultimately bear the commercial consequences of the dispute of outcome irrespective. So I'm going to be in the middle of this dispute, and I want a lawyer that is working collaboratively with me. So the best outcome, therefore, is usually achieved through a counsel and client work together to develop a strategy that is linked to the business objective. And the counsel that stands out are those who understand the background, understand the client's objective, remain responsive to changing circumstances and changing strategy and changing focus, and being easily available to adapt to deliver a win, or basically ensure that they deliver the broader client objective. So that is the lawyer I'm looking out for. I assume that most of those lawyers will pass the technical test.
Which is what I was going to ask a follow-on question, because all of these attributes, characteristics, all of these features, it presupposes to me that these are things that you will only discern when you have engaged the lawyer already, or somebody that has worked with you or is working with you. But for especially a startup law firm, a new firm that is trying to break into this industry, wants to get retained for the first time, and can demonstrate and can do all of these things that you have highlighted, can be an exceptional lawyer who looks at success not from his own perspective, but from the client's perspective, who is looking for a business win, but has never worked for you. What do they need to demonstrate that will make them, that will make them get retained? And I'm sure quite a number of our participants on the call are, looking at, are in that position right now.
A good question. Let me be direct in terms of the retention. When we make an assessment of which lawyer to engage, we sometimes come to decisions where we need to engage a panel and not just one law firm, because they bring different qualities. It could also be that this is a startup firm, and for certain strategic reasons, we would want to give them development opportunity because also we've seen their potential. But most importantly, the firm must also demonstrate that capacity to listen, that capacity to collaborate, that willingness to be able to go to extra mile to work to deliver positive outcome for the client. And as I said, they might not be in that competence level where they're able to deliver full-scale arbitration alone. But you actually see where maybe they are inviting one of their partners to speak as an expert in the arbitration, and you see that quality come out. So there are opportunities where you bring in younger firms or younger lawyers, or firms that are also, they've not done high value arbitration. But just to be clear, depending on the complexity and the value at play, you also be looking at firms with experience. I would not, so they'll have demonstrated track record of managing such high value arbitration. And then the opportunity to set up a panel where you bring other firms who are also upcoming to work with these firms, and of course, present them an opportunity to learn and further develop their competencies still exist. And that's where the opportunity lies. Nick, back to you.
Yes, you said you must see the potential. So it's left for whoever wants to break into the industry to make people see your potentials through your thought leadership and being, participating in one form or the other in industry, in the community events and activities. Yes. Okay. So, last question for Austin. For practitioners interested in the oil and gas disputes, what opportunities exist within the sector, particularly from the regulator's perspective? How can they meaningfully engage industry stakeholders? Please, in 2 minutes. Thank you.
So practitioner interested in oil and gas disputes and they want to be a practitioner as either arbitrators or mediators. There are a series of opportunities therein. Practitioners can act as arbitrators or counsels to license holders, operators, communities. There are a series of disputes in the upstream oil and gas sector, which I had earlier on enumerated, and practitioners who have track knowledge in oil and gas will become handy. But even if you don't have this knowledge, take some training, develop your knowledge. You have to be familiar with the governing laws that governs the oil and gas industry. Take training on to become an arbitrator or a mediator, and then you can then act as either an arbitrator or mediators in matters that involve operators, host communities, third parties. And because these disputes are so numerous, your expertise in the oil and gas will help you in being able to be choosing to act for the parties. And of course, participate in events like this where you have opportunity to see openings that are abound to you. And so I encourage lawyers, non-lawyers who are listening to this program today to avail themselves of this great opportunity and then seize the opportunity to benefit from being either arbitrators or mediators to operators, contractors, and host communities. Thank you.
And to Matthew, your last question. Though I still have rapid fire questions for everybody that I hope you will answer in 30 seconds. We'll get to that. So Matthew, looking ahead, where do you see the greatest opportunities for arbitration practitioners in the energy sector over the next decade? And how can practitioners position themselves to participate in those opportunities? This is practically what everybody has been saying, but let's hear from you, particularly from the international arbitration practice perspective. Thank you.
Okay. Well, I think people who do arbitration for oil and gas are lucky and privileged because these cases do go to arbitration and they don't involve the state courts. So they are likely to grow because the money gets bigger, the tensions between the states and the investors get bigger, and the level of technical expertise, which means nobody understands it until they actually involve lawyers and experts, gets more complex, and that makes disputes harder to settle. The other thing where this is going, these cases are really, really interesting, and that's another thing that makes this a very attractive practice area. I was in the commercial court about 6 months ago on a strikeout, defending an arbitration award. And we were seeking to strike out the challenge to the arbitration award because it was rubbish, basically. And it was really interesting. The judge, although he had obviously made his mind up and that this was a rubbish challenge and would be robustly dealt with and struck out, he wanted me to explain what the case was about, what were the underlying commercial principles. And I thought this was quite interesting because an English commercial court judge hears lots of interesting cases all the time, but he was taking the time to find out what was happening in these oil and gas disputes because they don't come across his desk very often. So I think the numbers will grow, they will remain interesting, and this will remain a very attractive practice area.
Thank you very much. So to bring this discussion to a close, I will ask each speaker one of the following questions and invite you to give me succinct final thoughts, ideally in 30 seconds. And I will start with you. What is the biggest misconceptions lawyers have about oil and gas arbitration? Please don't tell me that there's no money in oil and gas arbitration. That shouldn't be, please. That's a question for you, Matthew. What is the misconception lawyers have about oil and gas arbitration?
Okay, 30 seconds. I'll do it in 10 seconds. The misconception is that it's expensive. It's not expensive, it's very expensive.
Oh, okay. It is very expensive. Yeah, I think there's a question in the chat box about how expensive it is. So I'm going to direct that to you. So it's not just expensive, it is very expensive. Why do you think? Okay, then we'll come back to that. Okay, so Nezrin, can a practitioner succeed in this field without industry knowledge, or is sector expertise essential?
Honestly, I think it's a yes. I think you can, but probably not for long. You might win a mandate every now and again, but I think to succeed long term and build a career in it, I think clients want to know that you know their industry and you know their business. Like Ikechukwu was saying earlier, you need to know the industry and the projects, the commercial realities to gel with the client so that they can trust you with their cases. So I think, yes, you can, but not for long. If you want a
Not for
whole
long.
career out of it, you have to get into the detail.
All right. Okay. Thank you. Austin, what is one thing participants should do in the next 6 months if they are serious about building a practice in oil and gas arbitration or mediation or dispute resolution related to the oil and gas industry, particularly the upstream oil and gas industry?
So what participants should do in the next 6 months for me is to first deepen your knowledge about the sector. If you must be a practitioner in the sector, you have to deepen your knowledge about the sector. Having deepened your knowledge, then attain training and certification as either a mediator or arbitrator. Now that will then give you the room to then benefit from the plethora of matters in the oil and gas sector. But you must deepen your knowledge. You don't necessarily have to be a lawyer to deepen your knowledge about the sector, but you have to understand the sector to be able to render valuable service required. It's a complex sector. Yes.
Thank you. Okay, and Ikechukwu, in one sentence, what does the future of oil and gas arbitration look like?
It is, for me, positive, and also there's a push towards ADR, like Austin also shared the ADR Center. So it's a growing market. Oil companies who want a quick resolution. We really don't want to stay in litigation for too long. Platforms that helps us deliver such quick resolution, preserve the relationship, and deliver outcomes that serves the business will always be welcome. So it's positive, and always happy to refer matters to ADR, mediation, arbitration, whatever, as long as it delivers a clear business objective for me. I mean, I have no value staying in court for a long time. It's just more of a distraction.
Thank you very much. So we have come to the end of the discussion session, and we'll just look at, I think we have about 1 or 2 questions. And there's a question from Gochukwu Ukamba. It says, many meritorious oil and gas claims in Nigeria sometimes never proceed to arbitration because of the costs involved. How do third-party funders source potential cases in jurisdictions such as Nigeria? And what role can local counsel and arbitration This is 4 questions in one. Okay, let's start with how can third-party funders source potential cases in jurisdictions such as Nigeria? He talked about the cost of arbitration and arbitration institutes, and what role local counsel and arbitration institutes play in bridging the gap between funders and claimants. So Matthew, you talked about how very expensive it is. Can you also let us, answer the question as to how can third-party funders source potential cases?
Yeah, so third-party funding is not enjoying a great moment right now. The market was big as a lot of people piled into it, but to be a successful third-party funder, you have to understand arbitration and you have to understand finance. And there's not many people who understand both. And so the finance people have lost sometimes lost big time in investing in cases where, in the end, the reward just wasn't ever going to be there. And the people who only understand arbitration have also lost big time because they might have invested in the right cases, but sometimes they were too cautious, and they also didn't manage to put the funding together in a successful way. So it's not a great resource and at the moment. And if you have another way of funding, if you've got bank loans, assets you can lend against, in a more traditional borrow against, in a more traditional way, that's usually going to be better. I'm sorry to say.
Okay, thank you very much. I hope that answers the question. There's another question here. It says that Nesrin spoke about giving the other party reasonable time for the claimant's case, which brings us to the question of delay. How does arbitration tackle delay, having in mind that these IOCs have projects they need to tackle? That is, pleading the cause of the corporates here. Will their projects be on hold while these disputes carry on? And this is from Destiny Ndubisi.
In my experience, the arbitrations don't actually stop the projects. So the projects carry on, or they happen at the end of the project. So it's not, in my experience, usual for a project to pause because there's a formal dispute happening. Of course, it's a headache running in the background. It's a lot of management time. It's a lot of cost for the clients. But the projects carry on. Generally, certainly in the APC world, the contractors just sort of build and build and build all their claims, and then they all come out right at the end. So the project the focus is on finishing the project for a long, long time. Once it's over, then the fight and the arbitration starts.
Okay, thank you very much. And to our last question, and this one is, I will just direct it to Matthew, who talked about investor state arbitration. How is how to proceed against corruption in investor state arbitration? That's $1 million question.
Well, unfortunately for Nigeria, it's a $5 billion question. I mean, this is a really big problem. And sometimes you reach the limits of what arbitration can deal with. When, unlike a state court, it doesn't have the power to compel disclosure, to compel witnesses, and certain situations of corruption to get behind the truth and to find out why a business has been done in a certain way. Hopefully, nobody is corrupt. If somebody is corrupt, hopefully the other side are good enough at litigating to work out that they are corrupt and prove it. And if that doesn't happen, hopefully the tribunal is switched on enough to work out that there is corruption at the heart of this arbitration. But sometimes this all fails. And what to do about that? Let's have another webinar, I say.
Okay, yes, corruption is a big problem globally, and it's very difficult. I understand it's very difficult to prove. So some of those allegations are not substantiated anyway. Thank you for answering. And the last question, and this is truly the last question. And thank you. And it's directed to Matthew, is also on the issue of cost. And it says, arbitration faces the big drawback of being so expensive that one of its biggest touted advantages, and I say so too, that it's one of the biggest touted advantages that it is cheaper than litigation has completely been lost. That advantage no longer stands. It's now a paradox. Is there not a way of limiting arbitration fees, etc., to make arbitration return to that advantage? They said no. Even Nesrin is saying no. She's
Maybe
saying
Nesrin
no
should
already.
Nesrin should explain that.
Nesrin, do you want to explain? And I would also like Ikechukwu, though we are running out of time, I would also like Ikechukwu as the first user, the private user, the one that that pays the fees, unfortunately, and I would like to hear your own thoughts. In 30 seconds, because we still have to get the branch chair to speak, to say hello to everybody. Yes, Nesrin, I can see you're about the issue of cost.
It's in my interest to say no, right?
Oh,
No, I mean, No, look, I think it is possible to limit arbitration fees, because arbitration fees aren't just lawyers' fees, of course, they're experts' fees. And in my experience, the experts' fees, because you've got so many experts, tend to actually way exceed the lawyers' fees. But there is a way, and some of the things I spoke about earlier about having more efficient arbitration, cutting out the fluff, making it focused, keeping, only going for the claims that have merit, not having bloated pleadings, not allowing your experts to write 300 page reports on every single tiny thing. Asking them and ensuring they make an effort to try and agree things with the other side's expert. These are all ways of limiting the time and the complexity and cost of arbitration. So they are there. I think, unfortunately, the nature of energy and oil and gas arbitrations is that they are complex. So there's plenty of scope for people to take advantage. So I think that's probably what I'd have to say on it. So
Thank you.
yes, it is possible.
It is possible. And what do you say, Ikechukwu? Is it possible? Is it possible?
Indeed, it's possible, but just let's, of course, admit that it's not cheap and it's not looking as if it's going to be cheap anytime soon. But of course, as Nesrin said, there are opportunities to manage the cost. And quickly, the dispute resolution clause is an important clause because careful thought must be given to how you draft it, comparative to the underlying contract and the size of business. I mean, if you have a 200 million naira project or contract, you cannot sit your arbitration in London, 3 panels, 3 members. It doesn't work. You need to opt for a local arbitration, maybe 1 arbitrator. Those are kind of some creative ways to make sure that, because once you agree the dispute resolution clause, then that is the dispute resolution clause. Whatever costs come out of it, you must, be able to accept it. So again, that's the other option. Also look at where are those opportunities for, early dispute resolution to avoid actually getting to arbitration. Austin has shared a good platform where there's a center that you go cheaply to go and resolve the matter. So instead of spending costs in arbitration, go to Austin Center. And, it could be that is where the outcome will deliver for you the value that you seek or the business objective. So, Nike, back to you.
Thank you very much. Last week, we had this commercial arbitration workshop that was graciously sponsored by Linklaters, and it was a collaboration between Linklaters, LASIAC, Lagos Chamber of Commerce International Arbitration Center, and the Corporate and In-House Council Committee of Chartered Institute of Arbitrators, which I chair. And one of the conversations, one of the issues that we discussed was in fact, all of the issues all turned on the cost of arbitration. And it's something that it's a continual conversation, to try and see how the cost would deliver value ultimately to the users, because it's something of concern. It's a pain point. Yeah. And the conversation will continue is ongoing everywhere. And I would say that is, I think, jurisdiction-based. Now, in Nigeria, it's a bit different in terms of domestic arbitration, to the extent that we don't see 75% of the cost being parties' cost, that is a counsel cost or experts' cost, which is what you see elsewhere. Here, it's 75% arbitrators' cost. I'm sure Ike understands what I'm saying. It's so different. You can manage your counsel cost here to a large extent, but arbitrators' costs is so high. And like I said, it's a conversation that we'll continue to have until we are sure that we are not demarketing arbitration ultimately. On this note, I would like to say thank you to all our speakers, Matthew, Nesrin, Ikechukwu, and Austin. You have done extremely well. Thank you for the insights and the expertise and that you have brought to the discourse. And I'm sure our participants are glad that they participated in this session. Again, I also want to thank all of our participants. Thank you for joining and staying on and for engaging as much as you can. This webinar is again, I'd like to also say that this webinar is hosted by the Chartered Institute of Arbitrators, and I'll be calling on Mrs. Olushola Adigbomire, the branch chair, to say a word or two before we close this session. Thank you.
Thank you very much. Just a word or two. Just to say thank you to all the speakers, thank you to the committee, thank you to Dr. Esson, and to all the over 300 participants who I see have all really enjoyed, engaged, because I can see the chat. And I know I see the participants are from all over the world, not just Nigeria. So it's a big thank you to everybody. It has been very interesting for me too, learning about the ADRC, what they are doing. And of course, I'm sure Dr. Esson would find out how our members can be a part of the whole thing, smiling, and of course, how can we reduce delays? The CIAB Nigerian branch is really, really interested in reducing, not reducing just delays, reducing the cost of arbitration. At some point, we had to do a new cost calculator, just bringing down the cost of arbitration, because it's a very big complaint we have had, especially from corporate and in-house counsel. So, we don't have 3 for the price of 3. If you're having 3 arbitrators, it's slightly lower than if you had to pay 3 arbitrators times 3. One, it's slightly low. And we're just working on making arbitration more attractive, even to corporate and in-house counsel. And that's why we have this corporate and in-house counsel committee who are doing a great job in bringing the arbitrators close to the in-house counsel, because I believe that they are big stakeholders in the industry. So once again, thank you very much for this one. We look forward to the next one. We have a webinar on Tuesday, and one of the last questions Dr. Esson asked was really spot on, because the webinar is about how to break into arbitration. That was part 1 2 weeks ago. Next week, we have how to break into international arbitration, how to go global. And I'm happy she asked that question of one of the panelists. What can you do to get into international arbitration? So it's like we're taking from that question into the bigger webinar next week, Tuesday. It's an international arbitration webinar as well. We have speakers from Iberia, from America, and one speaker from straddles between Nigeria and the UK. And I invite you all to be a part of it. Just go on our website, LinkedIn, there's information about it. So once again, thank you very much, Dr. Esson, and the whole team, and we look forward to the next one. Bye. God bless
Thank you very much.
Thank you.
Thank you very much, everybody, and have a good day. But before I go, I'd like to introduce our flagship event of the Chartered Institute of Arbitrators Nigerian branch is our annual conference, and this year is holding in Port Harcourt, ADR Center. It's holding from the 4th to 6th November 2026, and the theme is Beyond Dialogue, Delivering Excellence in Arbitration and ADR. One of the things that came out from this webinar is that engage, be part of the community, be known if you want to break into the industry, and if you need to be visible, you need to demonstrate expertise. Come to the conference and all of this opportunity you will have, and also be knowledgeable. The conference will afford you this opportunity. The registration is ongoing. It's available. The link will be shared to all the participants through email. Thank you again, our participants, for joining, and our speakers are awesome speakers. We are grateful. We hope when we call on you again, you would oblige us. Thank you very much. And Mrs. Adigbomire, the branch chair, we are grateful for this platform. Thank you, everybody, and have a good afternoon.
Thank you.